Good evening, everybody. I want to welcome members of the committee. We have Ms. Spruill substituting for Mr. Belanger. We have Mr. Dutremont, Mr. Francis, Mr. Kirsch. We have Mr. Cox substituting for Ms. Ross, and we have Ms. Sauer. This evening we'll be considering 7 bills. Bill number 178, the Miscellaneous Statutes Repeal Act 2019. Bill number 190, the Expropriation Procedure Amendment Act 2019. Bill number 191, the Legal Profession Law Foundation Amendment Act 2019. Bill number 193, the Statute Law Amendment Act 2019, number 2. Bill number 205, the Children's Law Act 2019, and Bill number 206, the Children's Law Consequential Amendment Acts 2019. We will be considering Bill number 178, the Miscellaneous Statutes Repeal Act 2019, Clause 1, short title. Minister Morgan, if you'd please introduce your officials and make any opening comments.
Thank you, Mr. Chair. I'm joined tonight by Kara Moen, Crown Counsel, Legislative Services Branch, Ministry of Justice. Kara Moen is Doug Moen's daughter and Sean Moen's cousin. Because it's her first time here and given the family relationship, I think we should all withhold our judgment until we see whether she's appropriately competent or not. We're also joined by Grant Zelenko, Executive Director, Livestock Branch, Ministry of Agriculture, and I've got staff from my office here as well, my Chief of Staff, Lynn Cox, and Wallace Maldman. I'd like to now offer opening remarks concerning Bill 178, the Miscellaneous Statutes Repeal and Amendment Act 2019. Mr. Chair, this bill will repeal outdated and obsolete legislation, including older acts that are no longer relevant, acts that have been replaced by new legislation, and private acts where nonprofit organizations have been continued under incorporation. Repealing this legislation will eliminate confusion and help maintain provincial laws that are up to date. Due to the housekeeping nature of this bill, the proposed changes will have no other substantive impacts. Mr. Chair, with those opening remarks, I would welcome questions respecting Bill 178, the Miscellaneous Statutes Repeal and Amendment Act 2019.
Are there any questions for the minister? Ms. Sauer.
Thank you, Mr. Chair, and thank you, Minister, for your opening remarks. I will open by welcoming Ms. Moen to her first committee as well, and having known her before this evening, I will say that she is more than competent in this role and to be here tonight. And I'm sure the minister would agree with me as well that the ministry is very lucky to have her. I am curious to know a bit about private acts in general, because this legislation does repeal a few private acts that I understand are now no longer relevant for the committee's purposes and for Hansard's purposes, because I don't think it's well known that there are these types of legislations, and if you could explain a bit as to why we have these and what their purpose and function are.
Prior to the passage of Business Corporations Act in 1977, the company's legislation that existed in our province was complex and required articles of association, objects clause, and a lot of detailings. A lot of entities prior to that time found it easier to ask the government to create a piece of legislation, bringing them into existence. Universities are, of course, creatures of status, but so were a number of private colleges and a number of other private entities that have existed. Over time, those entities have chosen to they've chosen to continue themselves under either the nonprofit legislation or under the Business Corporations Act if they're a for-profit entity. I leave it to the officials to correct me or add anything if there's anything further that's
Darcy McGovern. That's exactly right. The history on private acts is also a technical one within, as the member will of course know, as within the rules of the Assembly. A private act will only apply where it is singular to that organization and is not taken to have a broader public purpose. So unlike a Business Corporations Act, which is a law of general application and which would be introduced in the Assembly by the government of the day, as the member will recall on private acts are brought by a member of the Assembly for amendment or initial introduction. When it comes to repeal, though, when the organizations have made it clear that they're either defunct or exactly as the minister just described, that commonly that they'll decide that they would prefer to be under the Nonprofit Corporations Act, for example, with the modern process that are built into those legislation, then they can make that change. So we still do see private act, but as you'll note from the notations on the headers, we've got a 1907 Act, a 1953 Act, a 1919 Act, and a 1948 Act. So these are historic, in two of the cases, religious institutions that are no longer operational.
Thank you. Now that the Business Corporations Act and Nonprofit Corporations Act have been in effect for quite some time, and like you said, a lot of the legislation that's being repealed today is quite dated. A lot of the legislation within that still use the private act sphere is quite dated. Has there been any thought by the ministry into looking into perhaps scrapping private acts altogether and forcing those organizations that still wish to use that structure to move into, for example, the Business Corporations Act structure instead?
And no, not as such, and use the term forcing. So, of course, the private acts are a prerogative of the Assembly as opposed to a invention of the ministry. So, I don't think it would be in our purview to begin with to get rid of those per se. But I think what we can do, and what we do with things like there's a process under the Nonprofit Corporations legislation that allows for an order in council process when an organization has indicated they no longer want to have a private act, to simplify them coming over to that nonprofit process. But there's still some relatively large organizations that are sophisticated organizations that prefer to maintain private status. So I can't say that there's been an initiative within the ministry to remove that as one of the options, though there's certainly fewer new ones than back in the day.
And what would be the reason why organizations would want to continue under that structure?
Well, and it's difficult to speculate, but it's specific to the organization. They're not public corporations. It used to be with some of the religious societies, particularly, that they didn't really have a corporate structure. And as the minister mentioned, in previous days before a nonprofit corporation, a simplified process, that was their existing option. And so there's a little inertia that also happens there.
Thank you. No further questions.
Are there any other questions? Seeing no other questions. Clause 1, short title, is that agreed?
Agreed.
Carried. Clause 2, is that agreed?
Agreed.
Carried. Clause 3, is that agreed? Carried. Clause 4, is that agreed?
Agreed.
Carried. Clause 5, is that agreed?
Agreed.
Carried. Clause 6, is that agreed?
Agreed.
Carried. Clause 7, is that agreed?
Agreed.
Carried. Clause 8, is that agreed?
Agreed.
Carried. Clause 9, coming into force, is that agreed?
Agreed.
Carried. Her Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts as follows the Miscellaneous Statutes Repeal Act 2019. I would ask a member to move that we report Bill number 178, the Miscellaneous Statutes Repeal Act 2019 without amendment. Mr. Dutremont moves. Is that agreed? Carried. We will now be considering Bill number 190, the Expropriation Procedure Amendment Act 2019. We begin our consideration of Clause 1's short title. Minister Morgan, if you have any opening comments, I welcome you to have them.
Thank you, Mr. Chair. I'm joined by Neil Carcutt, Senior Crown Counsel, Legislative Services Branch, Ministry of Justice, and Attorney General. I will now offer opening remarks regarding Bill 190, the Expropriation Procedure Amendment Act of 2019. Mr. Chair, this bill will reset the interest rate that may be awarded to landowners by the court in an action for compensation respecting expropriation. Currently, a judge may allow interest at a rate of 6% per year on all or a portion of the compensation awarded by the court. The proposed changes will require interest to be calculated in accordance with the Prejudgment Interest Act in the same manner as in other civil law cases. The current 6% interest rate has been in place since the Act was originally passed in 1968. Today, 6% is significantly higher than standard interest rates. For example, the published rates under the Prejudgment Interest Act for 2019 averaged around 1.6%. The proposed changes will ensure that prejudgment interest rates do not act as a deterrent for parties to resolve claims. The changes will also ensure that public funds are not used to pay an interest rate to landowners that is well above standard rates. Mr. Chair, with those opening remarks, I will welcome any further questions respecting Bill 190, the Expropriation Procedure Amendment Act 2019.
Are there any questions? Ms. Sauer.
Thank you, Mr. Chair, and thank you, Minister, for your opening remarks. Could you explain to the committee why it was originally set at 6%?
In 1968?
Yes.
I wasn't old enough to drink then, but I was old enough to drive. I'm guessing that that would have been typical of what interest rates might have been around that time. I went to law school during the 1970s, and I remember interest rates going from 12 to 17% during my articling year. So 6% would have been, I'm guessing, a market rate at that time. Sorry for the long answer.
No, thank you for that answer. I'm surprised that it hadn't been looked at to be changed until now, considering how dated it is. Is there a reason why there has been a delay in updating this legislation?
Good question, and I don't have an answer. I know maybe Neil's got a better indication than I do, but I think it was one of those things that nobody had looked at, and there was not a lot of activity in the area. Go ahead.
Neil Carcutt, the Ministry of Justice. Yeah, that's correct. It was raised recently or in recent years, so it's been looked at now, and that's why it's being implemented at this time. But
what are other jurisdictions doing in this area?
So expropriation legislation across the country, there's quite a mixture of different models, but the approach we're taking here would be similar to what they're doing now in British Columbia and Manitoba, for example. So Manitoba cross-references their Court of Queen's Bench Act, which has prejudgment interest provisions in it, so it's similar to what we're doing here. Similarly, British Columbia has moved towards I think it's the prime lending rate, so that would be similar along these lines. Quebec does something similar where they cross-reference their tax legislation, and the rate from that in 2019 was around the 2% mark. Yukon also uses the bank rate, which is similar to prime rate, a lower rate. Some of the other jurisdictions still have the higher 5 to 6% rates.
Thank you. And how